My name's Umar Azmeh, and I'm an associate at BCL specialising in business crime, financial crime, investigations and sanctions. The sanctions work at BCL falls under the umbrella of the Financial Crime Practice Group, which is one of the four main practice areas at BCL. We at BCL have great experience and expertise in representing organisations and individuals, either domestic or international, who've been made subject to various sanctions regimes, and indeed those regimes could either be domestic or international. Sanctions are restrictive measures that can be taken against countries, organisations or individuals to pursue a particular policy objective, usually a foreign policy objective. And depending on the subject of the sanctions, they can take many forms. So for example, a country can be placed under diplomatic sanctions, and equally a country again, or an organisation, or an individual can be placed under financial sanctions or asset-based sanctions. In general, sanctions are imposed by one of three bodies, either the UN Security Council, a sovereign state, or another supranational organisation such as the European Union. When the UK was a member of the European Union, and indeed until the end of the Brexit transition period, the vast majority of sanctions imposed by the UK government were actually EU sanctions, which were then made part of UK law. From the end of the Brexit transition period and going forward, the vast majority of UK government sanctions will be imposed under the Sanctions and Money Laundering Act 2018, or SAMLA. SAMLA gives the UK government the power to make regulations and impose sanctions for a variety of different objectives. And these sanctions can take many different forms. They could be financial, they can be immigration-based, they can be shipping or aircraft-based, or they can be taken as a result of a UN obligation. Sanctions can have a devastating impact on their subjects. So for example, they may result in the freezing of banking facilities, commercial partners may refuse to trade with a sanctioned entity, they can result in travel bans and of course losses of livelihood for people. It's important to note that the sanctions under SAMLA that the UK government are able to impose can be imposed in a much wider set of circumstances than was previously possible under the EU regime. The UK government has a significant amount of soft power, and as this is a new piece of legislation, it stands to reason that the UK government will seek to use it as much as they possibly can. This means that countries, entities and individuals may find themselves coming under increasing scrutiny from the UK government under this Act and regulations made under it. Indeed, it's important to note that the UK Consolidated Sanctions List is already over 500 pages long, and this is where it's important to obtain early and effective legal advice. We at BCL are well placed to advise any prospective client who faces sanctions. We will take that client through the options and the strategy available to them. We will deal with immediate problems such as the unfreezing of assets, and we will advise the client how best to obtain redress quickly and effectively in what is often very, very stressful set of circumstances.